All rise. The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated, everyone. Welcome to this special session of the Iowa Supreme Court held at the Law School at the University of Iowa. We have one case will be submitted this morning. That case is State of Iowa versus Dinte Williams. And Mr. Buller, you may proceed.
May it please the Court? The rule that this Court announced in State v. Wing has proven to be unworkable in practice. It's time to overrule Wing and realign this Court's case law with the statutory text. And that's where I want to start our conversation today. I want to go back to basics and talk some about the language that appears in Iowa's Speedy Indictment Rule. The language of the rule is that it is triggered when a suspect is arrested for the commission of a public offense. And I read that whole thing out loud for a reason, and that's because the language matters. It doesn't say arrest. It doesn't say detention. It doesn't say when a person is brought into custody.
Well, isn't the purpose for a commission of a public offense to distinguish arrest for a public offense from arrest as a material witness and arrest pursuant to parole or probation?
No, Your Honor, I don't agree. The language arrest for the purpose of, or for the commission of a public offense is to link the language of the rule to Iowa Code Chapter 804. They were both enacted at the same time. So we looked at 804 for the definition of an arrest. And
right.
There are two ways a person can be arrested in Iowa. The first is on a warrant, and that's when a complaint is filed and you can actually see what the offense charged is. The second was without a warrant under 804.22. And there, the person will be told what they are arrested for, and within 24 hours brought before the magistrate where that complaint is sworn out.
Right, but for a warrantless arrest under Section 407 of the Code Chapter, a warrantless arrest, it can be made for a public offense. I mean, that's the language.
Yes.
Obviously, you don't have a filing of a court document for a warrantless arrest. So the language in Section 407, which says that a police officer can do a warrantless arrest for a public offense, suggests that an arrest for a public offense does not require a formal initiation of court proceedings, does it not?
I actually disagree because that's only one portion of Chapter 804. If we look at 804.22, that's where we actually find all of the procedural requirements for the arrest if it's done without a warrant. Within 24 hours, that suspect is brought before the magistrate.
Yeah, but at the time of the arrest, I mean, you know, we all know what a warrantless arrest. I mean, you see a felonious act in your presence, you make a warrantless arrest. You don't file something with the court and come back and do it. And the language that was used in this code chapter for a warrantless arrest says that a police officer may make a warrantless arrest for a public offense. So the term for a public offense doesn't mean there's a piece of paper on file.
Your Honor, I disagree. It does. If you look at 804.22, that's explicit. All of 804 has to be read together. If you're just only looking at one component, you just get one tiny piece of the pie for what we're talking about. Under 804.22, that warrantless arrest is not effective until the person is brought before the magistrate. The complaint is sworn out.
The arrest is completed. Arrest is defined as including, and the course in Section 405, including restraint of liberty. The arrest occurs first, and then you're presented for the magistrate.
Again, Your Honor, that's just one piece of the puzzle. If we're looking at 804.22, that person must be brought before the magistrate in a complaint.
After the arrest.
No, Your Honor. After he's brought into custody, certainly I'll agree with you there for Fifth Amendment purpose. He's also, most likely, he's been seized for Fourth Amendment purposes, but arrest for the commission of a public offense is a term of art under the code. And for that, we have to look at all of 804. And let me suggest that if you aren't buying what I'm saying, there's another route you can take here. These suspects weren't under arrest because even if it was a warrantless arrest and we don't look at 804.22, there was no purpose to arrest affected. They were not told you're under arrest for X. They were probably in custody for Miranda purposes. They were probably seized for the Fourth Amendment, but they were not arrested for the commission of a public offense.
You take the position that, we interpreted the statute, and we came up with the interpretation that basically says, we think the soundest approach to determine whether a reasonable person in defendant's position would have believed arrest occurred. And now you're telling us that's unworkable because maybe the police don't understand it. But the test for Miranda for the last 50 years has been whether a reasonable person in defendant's position would understand themselves to be in custody, which is basically the same as
And if we were
arrest in custody. So why can't the police figure it out? And why do we have to change the rights of these of ordinary citizens to protect police and prosecutorial error?
I think your question answers itself in a sense. The test that this court used in Wing wasn't the test for arrest for the commission of a public offense. The test came from Miranda. It seems to be custody for Miranda purposes or probable cause seizure purposes under the Fourth Amendment.
So if we narrow the Wing test to say when a person reasonably believes they're under arrest for a public offense, that would meet your requirement.
It would be better than the current rule, but that's still not the language of the code. We still have to have the officer state the purpose of the arrest. You're under arrest for X. We don't have that in this case. We would also have to have the requirements.
But Counsel, our case law, there's a long line of cases that suggest to us that we've interpreted the statutes and the rule not to require the officer to say you're under arrest in order to constitute an arrest. I mean, there's a long line of cases that say that. You're not telling us that the rule is if the officer doesn't tell the defendant you're under arrest, that there's no arrest, right?
For purposes of Chapter 804, a person is not under arrest unless the officer affects a purpose to arrest them. That may not require the magic words of you're under arrest, but the suspect needs to be told that you're being taken into custody for purposes of an arrest, not a detention or an investigation.
Well, I appreciate I think you're spot on in wanting to look carefully at the language in context. You got me 100%, so I'm that far down. But looking at the language in 405, which is the arrest language, it's located, by the way, in a division of the chapter called commencement of actions, not in the search and seizure section. So this definition of arrest seems to apply rather clearly to speedy indictment problems. It characterized arrest as including a restraint, it says comma, including a restraint of liberty.
And I think we have to look in front of that comment where it says that the arrest is in the manner authorized by law. That's Chapter 804.
Yeah, or a restraint of liberty.
I'm not sure it says or, it says including.
Okay, it says including, fair enough. It says including a restraint of liberty.
And I think that's a restraint of liberty in the context of the procedural requirements under 804. I want to pivot back a little bit to Justice Heck's question and talk a little bit more about the past case law here. There's absolutely inconsistent language in our case law. There are some old cases that decide this arrest question by looking at those Fourth and Fifth Amendment principles. In those cases, that wasn't a problem because we got to a result that was consistent with the statutory language. But if we really drill down, we see that what this court has said repeatedly in cases like Johnson-Hughey, Gathercole, Dennison, and Raines is that arrest under the speedy indictment rule is defined by Chapter 804. And more importantly, this court has repeatedly said, and it says explicitly in Raines, a de facto arrest is not an arrest for purposes of the speedy indictment rule. I think all the questions I've had from the court today might go toward whether something is a de facto arrest, whether it's a seizure under the Fourth Amendment, whether it might be custody under the Fifth Amendment, but that is not the same question we're talking about.
The Counsel isn't our most recent precedent Wing, and if we overrule Wing, every time we overrule a case, doesn't that undermine the predictability and stability of our law?
I know the court knows that the state is very, very infrequently here asking the court to ever overturn its past precedent. The problem is that if there is a bad case, when is the good time to take that case on? To the extent that there is a Goldilocks zone, when it is not too soon, and when it has not been too long. It is now. It's about 6 years out. If we were 1 year after Wing is decided, I think the defense argument that we need to let this percolate and see what happens might be a good one. But that's not the case. We have seen problem after problem with Wing. This court saw it in Penn Kennedy, where there was no way to reasonably apply Wing to that situation. So what the court did was really chip away at the heart of Wing, really narrow it.
If it's such a problem, why didn't the legislature step in and fix the problem? You know, they're the ones who made the rule. We interpreted their rule. There's been 5 years, and they haven't made a peep.
Let me give you two responses to that. First, I don't think what this court did in Wing is statutory construction. If we look at the language the court used, the soundest approach to the question, that's public policy.
Well, whether it was statutory construction or not, they could rewrite the law. It wasn't on a constitutional basis. They could say arrest occurs when the Attorney General or the state wants it to occur. But they didn't do it.
And the second part to my answer, Justice Wiggins, is that I'm not sure anyone quite understood what Wing said until we started to try to apply it. Wing really did sort of come out of nowhere if you're looking at the case law. Our brief talks about how there are really these two separate strands of case law that suddenly converged.
We're talking 6 years and either 2 or 3 sessions of the legislature. And I don't even know if there's an amendment ever introduced, let alone somebody raising a problem. At least that's what my research shows me.
I think we all know that when a case is decided, you aren't going to see a problem the very next day.
Oh yeah, we did a case on Monday and they changed the law on Wednesday. I mean, dealing with coaches, whether or not they're subject to sexual predator statutes. We did a case on a Friday, and 2 weeks later they changed the law on recreational use. So I think your argument is a little wrong.
Could you address the practical problems from Wing, including if somebody's brought into the station and questioned, but they're not sure who committed a crime, isn't the state in a dilemma of either having to charge the wrong person or it's too late, even before DNA evidence is back?
Sure, that's exactly what we have in this case. There were approximately 8 suspects found in a known gang residence, and they were alleged to have been involved in gang raping 2 underage girls. One of the underage girls escaped. She called the police. One of the underage girls was still in the basement. The police in this case really did what they were supposed to do. They detained the suspects. They got a warrant to search the house. They sent the little girl victims to the Child Protection Center for an interview. They collected vaginal swabs, buccal swabs, penile swabs, and then sent those to the lab.
So, Counsel, though, but all that was done very quickly. And in terms of the time lapse here, isn't it true that there was no suspense about whether this defendant, Williams, was involved in the alleged offense? I mean, the same day of the offense, he says, "Yes, I had sex with both of those girls." I mean, you didn't have to figure out whether this defendant was the right guy, and yet 16 months elapse before an information is filed. So this really isn't a good case, is it, for the state to say, well, you know, we needed time to figure out if this particular defendant was the right guy or whether there was probable cause, and so we couldn't make a decision in 45 days.
I've got a couple answers. I want to make sure I get through all of them. First, it's not this court's position to tell law enforcement when their investigation is thorough enough and when the investigation should end.
Well, except that you have a good cause exception. I mean, this rule isn't ironclad. Was the good cause exception litigated below?
It was.
And what was the response?
That is not the issue that the district court decided the case on.
And what's your response?
Well, my response would be there may be good cause in this case, but the bigger problem is with Wing.
Well, maybe not. If there's good cause in this case, the bigger problem isn't with Wing, because Wing, in fact, is not an inflexible rule. If you look through other states, they use varying ways to have escape valves. Some states have a laundry list of exceptions. Federal has a laundry list of exceptions. In Iowa, they chose to have a somewhat accordion exception. I mean, it's a good cause exception, briefly stated. But to the extent there are difficulties from time to time, that, as you say, if law enforcement does exactly what we'd expect them to do and so forth, why wouldn't the good cause exception be adequate for those relatively rare cases?
And it might in some cases, but then we're trusting a district court judge to make the right discretionary
We do
call.
that all the time, don't we?
Absolutely, but this is a situation that has been created by this court's precedent. I want to get back to Justice Heck's question about, didn't we know enough basically right away after this happened? And the answer is absolutely not. Just look at the testimony of Bryce Lippert, the Waterloo police officer. He's not sure he has probable cause to arrest someone that night. I think he probably does, but he doesn't know who had sex with who. The two little girls aren't able to identify their
Wait, no,
attackers.
that's not right. I mean, Williams conceded. He admitted when they took him to the station. I had sex with both of these girls. So, I mean, it's not right. Maybe
Your
as
Honor.
to the other defendants, I concede, you might have a valid point that they weren't sure whether they were involved or not, but that's not true with Williams, is it?
And if I went to the district court and tried to prosecute that case solely based on Williams' confession, this court would say that that is insufficient as a matter of law. The purpose of the speedy indictment rule is to allow both the state and the defendant a fair amount of time and ensure that evidence is not lost.
Doesn't the record indicate that at least one of the individuals who was brought down to the station was exonerated because of the passage of time and allowing the tests to go forward?
I see my time has expired. With the Chief's permission, I'll answer. Yes, that's exactly correct. I want to talk briefly about that person. His name is Dorian Clark. Mr. Clark was at the residence. He was one of those 8 suspects, and he was exonerated after the testing of the vaginal swab, the penile swab, and the used condoms that were found in the basement. Because none of that DNA linked Mr. Clark to the scene, he ultimately wasn't charged. But if Wing was right, and everybody was arrested on June 10th of 2012, then the county attorney should have filed an indictment, charged Mr. Clark, and prosecuted him, even though the police could have eventually cleared him of wrongdoing.
Thank you, Counsel. Mr. Goldensoph, will you present your argument?
Thank you, Your Honor. May it please the court. Your Honors, last year in State v. Penn Kennedy, this court correctly identified that in the vast majority of cases, there's not going to be any sort of mystery as to when somebody's arrested, because there's going to be this familiar procedure that's followed, in such that a cop says, you're under arrest for whatever. They're taken down to the jail, booked, and the following day they have, the prosecution starts with an initial appearance. But Penn Kennedy says that there is a narrow subset of cases in which that process doesn't immediately begin, and that's what Wing addresses. Wing addresses that narrow situation, and it says that in those situations, if a person believes that they're under arrest for the purposes of speedy indictment.
Isn't it actually if a person would, a hypothetical person would reasonably believe? Because I think there's some evidence that this person understood he wasn't under arrest.
You're right, and I misspoke. If a reasonable person would have believed in that situation, that person was under arrest. And I would note that the district court in this case did find that the defendants were under arrest, or would have believed, a reasonable person would have believed that in their situation they were under arrest.
Well, wouldn't it be a lot clearer and easier if we had a bright line rule of that the clock doesn't start running for a speedy indictment until you're charged? Then everybody knows, and we don't get into this need to litigate whether under a particular set of facts they reasonably believe they were under arrest or not. We all know.
Yeah, perhaps. However, the problem is that Rule 2.33 says arrest is the triggering event, not what it used to say. We used to say held to answer. In that situation, people understood that once you're charged and held to answer those charges, that's when that's a pretty clear indication. But in 78, the legislature changed it to arrest, and
but let me follow up on that. Did Wing read out what was the clear rule that Justice Waterman talks about when it defined arrest not just to mean when a person is taken into custody, but it goes on to say that when a person is taken into custody in accordance with the law. Why did the legislature add that part to that definition?
Are you referring to 804.5?
Statutory definition of an arrest.
Sure. Your Honor,
Wing just says it's when a hypothetical reasonable person would believe they're under arrest when they're in custody, then that's the arrest. But why, if that's the case, why would the legislature add the condition in accordance with the law?
Well, Your Honor, I think
because doesn't the statute go on to then define what an officer is supposed to do once they take them into custody? They have to say certain things to them. They have to take them down before the magistrate, and there's additional procedures that all attached. Is that the law that's a part of the arrest?
Well, Your Honor, I think the Wing Court got it right when they said that the 804.14, the procedure, is the procedure that the officers are obligated to do when they're effecting an arrest. Now, if the legislature wanted the arrest to strictly include, telling the person what they're under arrest for, that they're arrested, and I'm a police officer, if they wanted to provide that, they would put that in 804.5, which is called the definition of arrest.
Well, what's the meaning of the language then, in accordance with the law?
Well, Your Honor,
I
think you're correct that refers to 804.15 and all of 804 and 805, but I think that's an indication by the legislature that we expect police officers to do this stuff. But
as a part of the arrest?
No, I would disagree, because if they wanted it to be as part of the arrest, they would have put it in the definition. What they did is they directed the police to follow this procedure, and the fact that they don't follow the procedure doesn't negate the fact that they were in fact arrested under the 804.5.
But don't you think that law enforcement is intelligent enough, articulate enough, they know what the statute provides if you're going to initiate an arrest? Wouldn't you agree with me?
Yeah.
Okay, so they know what they're doing somewhat by the mere fact that they didn't even take really any of the steps to formally initiate an arrest pursuant to the statute. Isn't that pretty good evidence that they were not intending to arrest Mr. Williams at this time?
Well, Your Honor, there's nothing, as the Wing Court pointed out, there's nothing in 804.5 or even 804.14 that requires purpose to arrest or the subjective intent of the officer for an arrest to occur.
But don't you think law enforcement is, again, intelligent enough to know that if I'm going to formally charge somebody with this offense, they know what the law requires them to do to facilitate the arrest?
Again, Your Honor, I assume that they do. At the same time,
to me, Wing has this standard of what a person under the reasonable circumstances is going to believe. And I guess I'm troubled by, again, the fact that the defendant then under any of these cases is always going to say, well, I reasonably thought I was under arrest under these circumstances. And I think it just creates a kind of a squishy standard here.
well, Your Honor, I believe the standard was put into place because this Rule 2.33 is a rule protecting the defendant. It's not a rule that protects the state or the police. And so
really protect, don't both the police and the defendant, have rights under that rule?
Yes. However, I think in order to I think when you look at this, I think the court in Wing will strike that.
Well,
Maybe you can
I'm
have that in the
not
record
arguing-
here. Is there anything in the record here where the police said, you're not under arrest? I mean, any indication of that? I mean, that would have led a reasonable person to believe they weren't under arrest.
No, they never said anything like that. And what actually happened is my client was sort of caught as he was walking away. The officer approached him and said, "Hey, do you know who owns that motorhome?" Waiting at a motorhome. My client said no, and then cuffed him, put him in his squad car, took him to the house, where my client watched the Waterloo tactical team enter the house, and he and the co-defendants were trooped out, many in their night clothes, taken down to the police station, examined for an hour. He had a buccal swab and a penile swab conducted on him. And going back to one of the issues that happened to Your Honors is that to the extent that there was any inability for the state to fully proceed with this case because the buccal swab testing hadn't gotten back, the record provides that the test results for those swabs came back, I want to say it was sometime in March or April. But the indictment or the trial information wasn't filed until November. So for the state to claim that the police didn't have probable cause in this case to proceed with the case is very, very weak.
Right, but even that would have been outside the deadline in the speedy indictment.
It would have.
Now, let me ask you a question. One of the amicus briefs, or the amicus brief, makes the point that if you actually go back to State versus Schmidt, 1980, decided right after this new language is adopted, so it's kind of fresh, and presumably the people that were around then would have been familiar with the background and the purpose of that rule. They say in the court, or we said in that case, that you need to look to the statutory definition of the arrest in 804.5. We're being asked today to overrule Wing. Didn't Wing overrule Schmidt?
No, Your Honor, I would disagree. I mean, if you look at 804.5, I mean, it's actually, I would argue, a fairly broad definition of arrest, and it's taking a person into custody when and in the manner of authorized by law, including restraint of the person or the person's submission to custody. Now, as has been indicated earlier, refers to the manner authorized by law, but it doesn't specify where we look to that.
Well, let me ask this question. This troubles me some. I mean, in Wing, we talked about whether a person would reasonably believe they're under arrest. But there's some evidence in the record that subjectively, I believe, your client did not think he was under arrest. And I'll get Mr. Buller excited when I refer to Wren. I mean, Wren says we don't ordinarily look into the subjective motives of police officers. And then the question arises, yeah, but if the police officer actually says that they had a racially discriminatory motive, wouldn't we look at? But here, although the general rule might be, we look to objective reasonableness because we're not going to be psychiatrists, we're not going to, kind of get in somebody's head. But here, it's a little bit different, I believe, because there's at least some evidence in the record that he didn't think he was under arrest. Help me out.
Your Honor, I actually looked at the transcript during the portion where my client was testifying again last night, looking for that very issue. And to be perfectly honest, I didn't see a portion in there where my client said, I didn't think I was under arrest. Rather, he said, I thought I was under arrest. Now, when the state cross-examined him and asked, what were you under arrest for? He said that he didn't know. Later on, he did clarify that he thought it must have had something to do with the assaulting the girls, because the line of the questioning that the police were involved with him. So I guess I didn't myself see a situation where he said, I didn't think I was under arrest.
Well, and isn't it also natural that if you are in fact under arrest and you believe that you're actually under arrest, that some type of criminal complaint is going to be filed? They're either going to make you go to your initial appearance and answer to the charge, at least appear in court before a magistrate do something else. But these individuals were, they were questioned, they consented to the various swabs that were taken in this matter, and then they're released. They aren't given a court date to come back and show up. They're not told or advised of any specific charges, certainly, that they're being charged with, and they're free to go. And they were. That's pretty unusual, isn't it?
Yeah, and that's why in this court's opinion in State v. Penn Kennedy, it identified that that's the sort of situation, that narrow subset of cases where prosecution doesn't immediately follow an arrest. That's when Wing applies. And I guess I would also further note that I don't know that the average reasonable person knows the procedure for a criminal case. So they may not know about, okay, now tomorrow I've got court because I have to go to my initial appearance.
Well, but even a person arrested for public intox the night before, and they're holding him until they can appear in court. We're talking a simple misdemeanor, public intox. We see them all the time in initial appearances. They're holding them until they have an opportunity after the complaint is filed. We're holding them. We look at the complaint, and they appear in court, don't they? And they pretty much know they've been arrested, and they're not free to go. They're not free to go about their business, and haven't been given a piece of paper, because these individuals are also given a piece of paper that tells them what they've been charged with.
I see that my time is up. Thank you, Your Honor. I agree, Your Honor, but again, this is that happens in the vast majority of the cases, as I said in my introductory remarks, and this is that narrow subset.
Counsel, let me ask you this question before you sit down, and as a little follow-up. We seem to be the only state in the nation that follows the Wing approach, where the speedy indictment is triggered based on the moment of a person who reasonably believes they've been taken into custody. There's a couple other states that use arrest as a triggering of the speedy indictment rule, but they do it in conjunction with either an arrest plus a filing of charge, or arrest plus continuous custody. What reason would there be for this state to have the only rule that we just start the rule based on the arrest out in some part of this state, wherever it might occur? Why would we want to trigger the speedy indictment rule at that moment in time?
Well, Your Honor, I guess at the outset I would note that the Iowa Supreme Court isn't shy from being in the forefront.
No, I agree with you 100%, but why is it that would be the time that we would want to begin that speedy indictment?
Well, Your Honor, I think it's just
it could be out in the cornfield. In other words, if someone is taken into custody in the cornfield in Iowa, why do we want to start the rule there?
Well, Your Honor, I believe it's just an interpretation of 804.5. I mean, it is, in my opinion, a fairly broad rule, and there's, I think that's just where the court came down with why we start things there.
Well, isn't it because you don't want the law enforcement to have the ability to delay filing of a complaint, buying a little extra time? The Second Circuit rule, contemporaneous with our statute in 1976 said arrest, ... filing of the complaint, whichever occurred earlier. So by differentiating arrest from filing a complaint, no question about it, you lose the certainty that was talked about a little bit down the line. Filing a complaint, being called to answer, has the plus of certainty. But by using arrest as a trigger, you prevent the possibility of manipulation of the timing of filing of a complaint.
And I would agree with that.
Well, would that minimize the rule that requires the officer making the arrest to promptly take the person before a magistrate?
No, Your Honor, I guess this just falls down to, that's an obligation that, when an officer makes an arrest, whether they follow the procedure or not, they've still made an arrest. It's their obligation to follow that procedure, and I guess I just keep coming back to the fact that they don't follow the procedure doesn't mean that the defendant wasn't under arrest.
Thank you, Counsel.
Thank you.
Rebuttal, Mr. Buller?
I want to start my rebuttal the same place I started my argument, and that's going back to the basics and looking very specifically at the language of the rule.
Well, before you go there, if you look at Miranda jurisprudence, the officers always say, you're free to leave at any time, blah, 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 and that way they avoid the custodial, the objective belief you're in custody and able to interrogate these people without giving them a Miranda rights. And I watch a lot of TV, maybe watch too much, but they take people into custody and say, you're free to leave, don't leave town, What is wrong with the officer just saying, in the swing test analogous to the Miranda, that, yeah, we took you down, we did all this, but you're not under arrest, and we may be getting back to you. What is wrong with that?
First, let me say,
If they don't think they're arresting him, you're not under arrest, we'll get back to you if we need you.
for Miranda, I'm with you. And importantly, Miranda is a constitutional decision, and we are not talking about a constitutional decision today.
But what's wrong with doing that in the arrest situation?
Saying
you're not under arrest, goodbye.
This court's role is solely to interpret the statute as written. If you were making a constitutional rule, as my opponent pointed
But you're
out,
making the argument it's unworkable. I don't know how it's unworkable if police would learn the rule and apply it.
I think the police know the rule, and the rule is in the statute, and that's why I want to talk about that language.
So they disregard our cases and only follow what they think the statute says.
As I said earlier, Your Honor, I don't think anyone quite understood what this court was saying and weighing. And if an officer has a choice of following a very clear statutory rule or a court ruling they don't really understand, I think we all know which is going to be easier to follow. The language of 8045 says that an arrest occurs when a person is taken into custody when and in the manner authorized by law. Where do you find out what that means? Go down the page. You're in the exact same chapter. 804.14 if it's by a warrant, 804.22 if it's without a warrant.
Yeah, and once again, a warrantless arrest can be completed prior to any filing of a court paper. I mean, I don't think anybody disputes that, and the statute provides for that. So a warrantless arrest is authorized by law. I'm reading from 405. It's authorized by law. 407 authorizes a warrantless arrest, and it includes restraint of the person. I've got the bear hug around the person. He's under arrest. I saw you, committing a felony. You are under arrest. The arrest is completed then. It's authorized by law. It's a restraint of liberty. No filing of a piece of paper.
And this is why the language is so important, because we are not talking about the word arrest on its own.
I agree.
We are talking about arrest for the commission of a public offense. And in Wing, this court read all of that language out of the rule. And really it read that when in the manner authorized by law language out of 8045 is someone in the bear hug, in custody for Miranda purposes? Probably. Is someone seized under the Fourth Amendment? Probably. Is that person arrested for the commission of a public offense? They are not, because that is not in compliance with the code.
Wait a minute. I just have to interrupt you. It was perfectly clear to everybody why Wing was arrested. A big brick of marijuana was found in his trunk. There was no mystery about why Mr. Williams was arrested. It very quickly, the conversation came around to the 2 minor girls who were in that house, whom he admitted having sex with them. So, I mean, neither Wing nor Williams were arrested for sport. They were arrested because they were clear suspects in particular public offenses, right?
The police are not required to arrest someone for every possible crime that the police have probable cause for. If you're right that these people were under arrest on June 10th, 2012, let me ask you, what were they under arrest for? Was it simple misdemeanor drug paraphernalia possession? The defendant was found with a marijuana pipe. Was it Class B second-degree sex abuse? Was it Class A kidnapping? Was it conspiracy? Was it contributing to the delinquency of a minor? Was it all of those? Was it none of them? Was it some of the 12 charges in between there?
Doesn't all that go to whether or not a person in the defendant's position would reasonably believe they're under arrest? And you may win factually. I mean, you could have that conversation just as Apple, because you raised it and I saw you pull something out of your folder, but that's a different issue. That goes to the question of whether or not, under those circumstances, someone would reasonably be under arrest. And I will grant you that that's a real question in this case, under these facts.
I see my time's up. If I could respond briefly. Your Honor, it's not just going to be a question in this case. It's going to be a question in a lot of cases. I very strongly disagree that it is the rare case where you don't know what offenses you are investigating. Every time the police respond to the scene of a violent crime, officers don't know exactly what's going on. They might have a tip from dispatch, but they're going in there fearing for their lives. They're going to detain the suspects, like they did in this case, and they're going to conduct an investigation. The speedy indictment rule does not protect people from a prolonged police investigation.
Let me just, I know you're wrapping up, but this is consistent with what you're saying. The prior rule, held answer, got you exactly where you want to be. Why was it changed?
Well, the entire code was changed,
Well, I
Your
understand
Honor.
that, but why did they just say held to answer? Or why did they use the term accused? And accused is always tethered to formal court proceeding.
I think
Instead they chose arrest, which ordinarily, by the way, I suggest, is not tethered to a formal court proceeding.
at the risk of drawing the broken record complaint, we're not talking about arrest. We are talking about arrest for the commission of a public offense. And that term of art means exactly what held to answer did. Our brief goes through all of the legislative history of the Federal Speedy Trial Act. We aren't talking about just an arrest. It's arrest for the commission of a public offense. And under the plain language of both the statute and the rule, Wing should be overturned, and this court should return to its prior case law. Gathercole, Dennison, Rings, a de facto arrest is not an arrest for the commission of a public offense.
Thank you, Mr. Bowler. Case of State versus Williams is now then submitted